is it reasonable and necessary for the applicant to explore the possibility that he's catastrophically impaired? And to complicate it even a little bit further, the burden of proof for reasonable and necessary is on a balance of probabilities. So to pull it all together, yes, an 18 for a CAT assessment will meet the test of necessary because it's the only meaningful way to be able to apply for catastrophic impairment. Reasonableness is it reasonable for the applicant to explore the possibility that he is catastrophically impaired, and the onus remains on the applicant to prove on a balance of probabilities that it's necessary for him to explore the possibility that he's catastrophically impaired. So it does get to be a little bit confusing, but I think the sort of the key takeaways from these two decisions that have recently come out is that, one, it's not a test of causation, right? We don't have to establish that the accident is causally linked to the injuries. That's left up to the CAT assessors. But you have to establish on a balance of probabilities that there's a reasonable possibility the person will be deemed has suffered a catastrophic impairment. There has to be consistency between the treating records and what goes into the OCF 18. And thirdly, at the end of the day, procedural fairness is going to rule. That's not going to allow, the insurance company, in the example of the last case, to have the upper hand, right? Where the insured had his 19, the insurance company had their IEs. So even though these were technically rebuttal reports to the IEs, based on procedural fairness, the insured still got to go ahead with the assessments funded by the insurer. So
Stacey,
I'm going to
ask you a question.
Yeah.
So let's say, you have a client or a patient who is nearing the end of their med rehab limits for non-catastrophically impaired. What consideration should be given to start going down that, catastrophic impairment road, which might be quite costly in terms of doing assessments to move that forward? How does that relate to this reasonable and necessary business?
From my perspective, when we look at this stuff, it's really looking at least I try to take sort of an objective review of the file to figure out, in my mind, whether or not there is a reasonable possibility that the person's going to be deemed catastrophic. If you've got someone who has ongoing attendant care needs, for example, and we're not really talking about a couple hours a day here or there, but if you've got someone who still has rather significant attendant care needs, that there is still a full treatment team in place, that you've got full support of the treatment team, that there's going to be significant ongoing costs, then it's worth going down the road. If you don't have that, right, there's in some cases we've seen where, other firms have gone ahead, put the client through the CAT assessments simply for negotiating reasons, right? To give us a little bit of leverage, create some exposure for the insurance company, and see if we can, squeeze out a few $100,000 more. And I get it, right? Because it gives the client a bit more money. It gives them access to more rehab, but it also raises the very likely possibility that we're going to end up with a set of negative IE reports in our file that could impact the tort case negatively, because all of the reports, all of the records that are prepared in the accident benefits claim become producible to the defense insurance company in the tort claim. And they grab onto them and they pick through them and they find all of the negative things that they need to help bolster their case on the tort side. Okay. Matt, for those of you who don't know, Matt used to do defense work before he saw the light and came over to join us. So Matt, can you give us just some insight, perhaps from the defense perspective, when we're talking about whether or not a CAT assessment is reasonable and necessary?
Absolutely. Thanks, Stacey. As you kind of intimated earlier with the case that you gave for an example, the last thing an insurer wants to see is an OCF 18 for about $30,000 requesting assessments. And they're looking at that in terms of the file. The adjuster is going to know the file to some extent. They're going to know whether or not there is, you know, some kind of prima facie indication of CAT. For example, someone with some minor soft tissue injuries versus someone with some serious subjective injuries. And so what the defense kind of panel has done over the years is find ways to try to limit those costs, to look at a file and either use the reasonable or necessary test and or the SABs to limit the costs associated with those types of assessments. And some of the things they'll be looking at is the relevancy. So as you said, the factual scenario, relevancy in terms of duplication of effort. So if an OCF 18, for example, has 13 assessments, 7 of which are arguably duplications of other assessments, or something even worse where the assessments are separated by tasks. So for example, an assessment for file review, an assessment for psychological testing versus the actual assessment for whether or not it meets one of the confines of the criteria of CAT. The defense panel will look at that and the lawyers will say whether or not those fees are reasonable and necessary pursuant to the requirements of section 25(1)(5) of the SABs, which says that these assessments for catastrophic impairment designation under 45 need to be necessary in order to go through. The good news is, from what you said and otherwise, is that regardless of when these assessments are conducted, the principles of fairness apply, and you're not going to have a scenario where you're not going to ultimately get paid for that. And it's important to note, in one of the topics of our conversation, is that this is not a med rehab cost. It is very clear that section 25(1)(5) separately requests, when putting in an OCF 19, the necessary reports to support that OCF 19 are paid separately. They are still paid at the $2,000 maximum plus HST, but they're separate and they come from the medical limits, either the 50,000 limits under med rehab under certain policies or the $65,000 limits under new policies.
So Matt, just to be clear here, let's say someone, you know, has exceeded their non-CAT med rehab limits, and you know, 2 or 3 years have gone by since the accident, and you want to apply for CAT. How can you fund that?
Well, the good news is that there's a few decisions that came out when confirming that CAT assessments are separate and apart from med rehab. Those decisions went under reconsideration to determine whether or not, if they're necessary, when they have to be paid for, okay? And in addition to the principles of fairness allowing for them to get paid for, if there is any reasonable suggestion of CAT, you're gonna want to speak with assessors, understand what is needed to specifically get that particular client to that area, and it should get funded. There should be no issue. The issue that Stacey brings up is that sometimes if you have a tort component, you can pay for overages because not necessarily $2,000 a pop is gonna cut it, and that's an unfortunate scenario. But when you're non-CAT and you're looking towards CAT, you have to follow Stacey's kind of example of going through the file and determining whether or not these reviews are happening. But the insurer should, and on hearing, will have to eventually pay for that, provided it's a necessary association. And the way you prove it's necessary is if there's a physician willing to file an OCF 19.
Matt, from my perspective, you know, the way I view it is, if someone, after they've exceeded their med rehab limits, may need additional attending care after 2 years, maybe even needs housekeeping. For me, it seems pretty reasonable to seek out a catastrophic impairment assessment if you require additional benefits above and beyond what's available to you at non-CAT. That's my own point of view. I don't think there's a case that says that, but I would think that that would be some weight or something that would persuade an adjudicator that maybe he does or she does need to have a catastrophic impairment assessment. Do you agree with that?
I completely agree with that. The two cases I'm thinking of, and everyone who's listening, I'm going to give the CanLII sites later, so don't worry. MG and Aviva was a decision that then went in reconsideration, and NS and Scottish and York. Look at these things, and my takeaway from it is that you're going to get the fees ultimately for those assessments, provided that they're not duplications of effort, they're not in excess of the $2,000, and that they're relevant. For example, if you have someone who's a minor injury and you throw an OCF 18 for CAT assessments either too early or under circumstances like psychological, when it's really a physical injury or what have you, those are going to be the times when you end up having problems with denials. If you have a legitimate injury where they've shown the need for the limits up to 65,000, and then you put in an OCF 18, it's going to be find a hard an adjudicator that's not going to have the medical records to support their findings that it was a necessary cost in order to fill the OCF 19. And then certainly if people are getting payments for certain types of benefits and then start this CAT process, there's certain provisions under the SABs that allow them to continue to pay while this thing gets ferreted out.
So thank
Matt.
you. If you don't mind, I just want to jump in on the last topic while we still have a few more minutes left. Is that okay?
Of course.
So, I'm actually get to respond to the question of the week that was sent to us this week. The question was sent by Daniela Kasky, occupational therapist. I hope she's out there. Her question, it was more detailed than what I'm about to give to the audience here today, but the gist of it was that a client of hers is living in, I believe it's a nursing home or a place where people are vulnerable. Before COVID came around, that person was receiving attendant care benefits from a professional PSW provider. Since COVID, they're very frightened about people coming in and providing those PSW services. And as a result, the person in need of care's mother, who I believe was retired at the time, is providing these attendant care services. And there was a suggestion that if the mother was being paid some of these attendant care services, that maybe she'd be able to do more or a more fulsome work for her loved one. And the question is, can, in these desperate times, in light of the fact that PSW workers can't go into places or certain facilities, or there's a lack of trust that a professional PSW worker would come into a person's home, is there some way to rejig the incurred expense portion of the attendant care claim to make this work for people? And unfortunately, the answer is no. And I have to go back briefly to explain this, but in 2014, based on the insurance company's request to the government, they made a change. It drove insurance companies crazy that family members could possibly receive attendant care monies for giving PSW support, attendant care support to their loved ones. We were able to sort of fight that over time and say, okay, listen, if someone suffered a small economic loss, perhaps that loved one, the family member, could get the whole attendant care benefit. Then the insurance company went back to the government and they changed it again. And now it's specifically that you have to prove a dollar per dollar loss for every attendant care or PSW work that you perform for a loved one. So in this situation here, when the mom performs these attendant care services for their child who's vulnerable, there's not much of a opportunity to prove that the mom suffered an economic loss. Now, I have one case where a daughter quit work and had to take a reduced pension in order to provide attendant care for their mom during this COVID crisis. And I'm making a claim to the lot saying that's an economic loss. She would have had a bigger pension had she not had to retire early. But there needs to be evidence of the economic loss. There's been 3 cases that have come out of the lot since we've been COVIDing. And it was all about this incurred expense business. And the lot keeps coming back over and over and over again, saying that we're not breaking the rules no matter what on this incurred expense business. And two is the applicants keep coming forward with a lack of evidence. And usually the lack of evidence is in two respects. One is not enough evidence to prove an economic loss. Economic loss can be considered broadly, as we just discussed. But if you don't put in evidence, oh, here's the employer who has a job offer for me, or this is my income loss through an account, you're not going to win. And on top of all that, the insurers are putting these non-accredited or family members providing PSW to the same standard they would put a professional PSW company to in terms of proving the incurred expense, the actual invoice. They're sick and tired of seeing one sheet of paper saying, you know, here's an OCF6, 1 month of attendant care benefits, and a number at the bottom. They want to see exactly, when I say they, I mean the lot. They want to see exactly what a professional PSW company would provide. They want to see a daily invoice. They want to see a total. They want to see exactly what services they provided. In terms of showing what services are provided, obviously you should go to the Form 1. But there should be something, if not contemporaneous or done on the same day, but weekly records to show what's being provided in order to match that up later with economic loss. Now, if what's happening in these cases where someone's coming forward and saying, oh, just generally speaking, I want $3,000 a month for attendant care. Well, what did you do? Well, I don't remember. I just followed the Form 1. Well, didn't your mother go into the hospital for 1 week to fix her broken leg? Were you providing attendant care for them every time they went to the hospital for that week? No. So there needs to be something, you know, legitimate about these invoices. They need to coincide with reality. And if they don't, they're probably going to lose at the lab. So I'm sorry for being so, you know, down on this aspect of the claim, but two things need to be remembered. One is keep records of what's being provided. Two is if a person's not in the actual business of providing the PSW support or is suffering economic loss, in all likelihood, it will not be compensable. I'm sure I'm running out of time, but let me just say that those records that you keep, even if it's not compensable, we could use that hopefully in a tort claim that that person may have and claim a suitable hourly rate that's, I'm sure, higher than the Form 1 hourly rates in the tort case. So I want to thank Daniela Kasky for her excellent question this week. We encourage everyone to send more, and we will answer these questions in subsequent seminars like this. And it's been a real pleasure speaking with you today.
I just want to follow up quickly with a couple of things that Michael has said. You know, in terms of documenting the economic loss, while we all appreciate that from a rehab perspective, it's really not part of your responsibility to, you know, help us prove that part of the claim. But just be mindful when you're doing the narrative parts of your reports or in your clinical notes of records that if it is a situation where a family member has given up work or passed like on a job offer, just, you know what, it always helps to just have that in there.
I totally agree. You know, there's truth and there's proof. And
yeah.
You really need that proof help when it comes to this incurred expense stuff.
And as for attendant care during COVID, just to follow up with on Michael saying, you know, it is sometimes, and I've had a bit of success in that where I've had a client who had significant attendant care needs at home and private PSW was coming in, COVID comes, now the private PSW is not coming in anymore. And I really think that if you've got a good adjuster, if you've got well-documented needs, great support from the rehab team in terms of what those needs are, and more than I think, like in my situation, was more than just sort of basic supervisory care, right? If you've got a real attendant care need, there is some way, some success in getting them to pay the family members during COVID. It's been limited and very much driven by the facts of the case and the adjuster on the other side. But I think I agree for the most part with Michael is that, you know, in most cases, the answer is going to be no, unfortunately.
Well, thank you everyone for attending here today. We're really enjoying this seminar series, and we look forward to being before you in short course. And please keep your questions coming. We love them, and we promise to address more if we get more good questions next time.
Mark?
Have a great weekend, everyone.
Thank you, everyone.
Thanks, everybody. Have a great weekend. Mark, did you want to say anything about the next one coming up?
In 2 weeks, look for the next invite.
All right, we'll see you guys in 2 weeks.